Good morning. This is the first video lecture that I'm creating. I've never done this before, so we are going to learn how to do this together. All right, this lecture is the very first under the new system, and let's simply call it the March 19th Political Science 201 lecture. And we are starting now with Article 4. We know that Article 1 dealt with the legislative branch. Article 2 dealt with the executive branch, and that Article 3 dealt with the judicial branch. So we've covered the three branches of government, but we still have a long way to go because Article 4 deals with the relationship between the national government and state governments. And it generally is what we refer to as the federal system. Now, most political scientists acknowledge that there are three fundamental forms of government. One is the form that was possessed by the Articles of Confederation Congress, and later by the government of the Confederate States of America during the American Civil War. And this style of government, and it should be no surprise to us, is called the confederal system of government. And in a confederal system, there are two fundamental levels of government. One is the national government. That's sort of obvious. But there are subsets for you mathematicians. There are subsets of government that we call states, and states maintain their own existence under the confederal system. As a matter of fact, under the confederal system, states have a lot of power. The power that's granted to the national government in a confederal system is rather limited. And we know that that's true from our discussions of the problems that were possessed by the Articles of Confederation Congress. Now, the second style of government is called unitary, a unitary government. And in a unitary style of government, there are no states or anything called a state or anything called something else that we would consider to be a state. For example, England has one government, and that is the national government. There are no states in England. There are counties, but those are really more geographical designations than they are political designations. And of course, there's what we have now, the third system, the federal system. This type of government blends the national government with state governments, but in a federal government, the national government, whenever there's conflict between the national government and state governments, the federal government, the national government, always wins. And we'll talk about this when we get to the 10th Amendment a little later on. So, what do we have now here in the United States? We have a federal system. It's transformed from a confederal system to a federal system. And Article 4 deals with that type of a system of government. All right. Article 4, Section 1 says, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. If you get married in Louisiana and you move to Texas, do you have to remarry? No. And the reason is that Texas recognizes your Louisiana marriage. The same goes for divorces. You don't have to get divorced every time you move to a different state. The same thing applies to, for example, the adoption of children. You don't have to go through that process if you move to another state. Every state recognizes the public acts, records, and judicial proceedings of every other state. And of course, Congress can regulate those things. But generally, the states have control over things, especially like family related law. Article 4, Section 2, Paragraph 1 says the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states, in the individual states. There's only one set of laws, and it applies to everybody. If you go on vacation to Illinois, there's not a set of laws for people who are Illinois citizens and a completely different set of laws for people who are visiting there. Everyone operates under the same set of laws. If you speed, you're going to get pulled over because of an Illinois law, whether you are an Illinois citizen or whether you are a Louisiana citizen. So you have the privileges and the immunities of citizens of the individual states. Article 4, Section 2, Paragraph 2 says a person charged in any state with treason, felony, or other crime who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. Now, we've mentioned this previously in this class. This whole idea is called extradition. And the fundamental rule is that if you do a crime, let's keep picking on Louisiana. You do a crime in Louisiana, and you run away to Alaska. Are you immune from punishment for the crime that you did in Louisiana? And the answer is no, you're not. As a matter of fact, if they can find you, of course, they got to find you. But if they can find you in Alaska, they can bring you back to Louisiana to stand trial, pardon me, to stand trial for the crime of which you are accused. Now, there are some internal rules here that must be followed, but these are commonly used and it's nothing special. The state that wants you back, in this case, Louisiana, has to go through a specific process. They've got to communicate with Alaska. They've got to communicate with the proper people. They've got to make the proper request. They've got to use the right paperwork, blah, blah, blah. I mean, after all, it is a bureaucracy, isn't it? But once all those I's are dotted and the T's are crossed, then you will be brought back to Louisiana and you will stand trial for the crime of which you are accused. Now, Article 4, Section 2, Paragraph 3 in your copy of the Constitution should be in italics or in bold or underlined, which signifies that this part of the Constitution is no longer in effect. But we need to find out what it said. So, Article 4, Section 2, Paragraph 3 says, no person held to service or labor in one state, under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. What in the world is this? Well, the simple answer is, this is the runaway slave provision of the original Constitution of 1787. Remember, slavery was, in 1787, legal in all 13 states. it was becoming less and less popular in the northern states, but it still existed in the northern states. Now, there would be certain states where slavery would be illegal from the very beginning. And we know that is the result of the old Northwest Ordinance, also of 1787, which said that slavery would never be able to exist in any states that might be carved out of the area of the old Northwest Territory. And we know that 5 states eventually were carved from that area: Ohio, Indiana, Illinois, Michigan, and Wisconsin. So, if a slave escaped into any of those states, was he forever free? And the answer is sort of. If he could avoid being caught, yes, he would remain free as long as he remained uncaught. But his master could come to Illinois and recapture him and take him back home and re-enslave him. Or the master could hire an agent to do the same thing. So, no person held, by the way, the word slave or the word slavery doesn't appear here, although that's exactly what they're talking about. They tap dance all around avoiding using this term. No person held to service or labor in one state under the laws thereof, in other words, a slave state, escaping into another, in other words, a free state, shall, in consequence of any law or regulation therein, right? Slavery doesn't exist there, be discharged from service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. Now, uh, think about this. This probably won't be on the exam, but think about this. We think that there could be nothing worse than being a slave, and that would be extraordinarily terrible. But I can think of something that would be worse than slavery, and that is having been a slave, successfully run away, live in freedom for a while, and then be recaptured and returned to slavery. Once you have tasted the sweetness of freedom, and then to be re-enslaved had to have been the very worst thing that could happen to a person. All right. Article 4, Section 3, Paragraph 1. New states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of 2 or more states or parts of states, without the consent of the legislatures of the states concerned, as well as of the Congress. Okay. Article 4 says, even though at the time that the Constitution was created in 1787, there were only 13 states, it was understood that additional states would join the Union at some undetermined point in the future. But it said it put limits on the creation of those new states. It says, but no new state shall be formed or erected within the jurisdiction of any other state. You can't divide one state into 2 pieces and then call the new piece a new state. Neither can you take pieces of 2 or 3 or 4 states and create a new state. Well, actually, I just lied to you. What Article 4 says is that you can do those things, but only if you have the approval of the states that are involved and the approval of the Congress. If the states won't give their approval, it dies. If the Congress won't give its approval, it dies. Now, some of you who know your American history are sitting there going, I caught Dr. Traylor in an inaccuracy. What about West Virginia? All right, for those of you who are not enlightened, let me tell you the story very quickly of West Virginia. As the nation was moving toward civil war, the southern states began to vote on whether or not they would stay in the Union or whether they would leave the Union and join the Confederacy. Now, Virginia, the state of Virginia, voted to secede. But the reality, and something that many of us don't know, is that the western counties of the state of Virginia did not want to leave the Union. They were very happy being a part of the United States. But when the state of Virginia as a whole seceded, it dragged the counties of Western Virginia along with them. But that never went down well with the people who lived out there. And so, once the Civil War began, the people who lived in the western counties of Virginia petitioned the United States government to remain in the United States. And the Congress approved that request. And as a result, the state of West Virginia was created. Now, some of you are saying, whoa, Article 4, Section 3, Paragraph 1 says you can't do that without the approval of the state. And Virginia certainly was not going to give its approval, right? Well, it might be a technicality, but the reality is that Virginia was no longer a part of the United States, was it? It was now a part of the Confederacy, and as a result, it no longer was operating under the United States Constitution, but rather it was operating under the Constitution of the Confederate States of America. And so, West Virginia didn't need to get the permission of Virginia because Virginia was no longer a state of the Union. Article 4, Section 3, Paragraph 2 says, the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. And nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. Now, the general process for becoming a state of the Union, now there have been exceptions. Texas was an exception, for example. Texas was an independent nation before it became a state of the Union. So I suppose there are always exceptions. But generally, the process that is used in order to eventually become a state is to become a territory first. Then you satisfy certain requirements, population and things like that, and then you apply for statehood. But while you're a territory, who is in charge of the government? Well, Article 4, Section 3, Paragraph 2 says that Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. So the United States made the rules for the territories. The United States made the rules for how many people a territory had to have before you could apply for statehood. The Congress made the rules for creating a judicial system in the territories. The Congress made the rules for appointing a territorial governor. And nothing in this Constitution shall be so construed, that's an odd word, shall be so understood as to prejudice any claims of the United States or of a particular state. Article 4, Section 4. The United States shall guarantee to every state in this union a republican form of government, and shall protect each of the states, pardon me, against invasion, and on application of the legislature or of the executive, the governor, when the legislature cannot be convened against domestic violence. All right, let's break this down. The Constitution guarantees every state a Republican form of government. Now, be very careful here. This is not a uppercase R Republican. This is not the Republican Party that's being referenced here. This is the lowercase r Republican, which is a style of government. In a republic, the people elect their own leaders. The people then trust those leaders to make appropriate laws. And then the people agree to obey those laws. That is lowercase r republicanism. And didn't I just describe the style of government that we have today? Lowercase r republicanism. That's the only form of government that is acceptable in the United States. If a state of let's be silly for a little bit. If a state decided that they wanted to have a communist form of government, could they? No, they couldn't. Article 4, Section 4 says that what is guaranteed is a Republican form of government, not some other style of government, and shall protect each of the states against invasion. So here are the responsibilities, here are the obligations of the national government to the states to protect each of them against invasion. I like to use the example, what if Cuba tries to attack Louisiana down at Port Fourchon? Well, what's going to happen? Well, the United States military is going to show up and kick some serious Cuban butt, right? Because there's an obligation on the part of the national government to protect the states. And on application of the legislature of the state, or of the executive when the legislature cannot be convened against domestic violence. What if riots break out in Los Angeles? And by the way, this is not an off-the-wall example. This did happen in the 1960s. The black areas of Los Angeles, the area called Watts, Watts, because of racial injustice, broke out in riots, and a lot of Watts literally burned to the ground during that time. The governor of California and the legislature of California requested of the national government help. They couldn't do it themselves. And as a result, the national government sent the military to Los Angeles to put down these riots. Ooh, that was Section 4. I'm sorry, Article. That was Article 4. Now, Article 5 discusses the way that the Constitution can be altered, can be changed. It's what we refer to as the amending process, the amending provision. The Constitution has been changed, has been amended 27 times during the nation's history. The reason it has only been amended 27 times is because the Constitution itself makes it very difficult to amend the Constitution. It cannot, because it's so difficult to amend, it cannot be amended for frivolous or silly or unimportant reasons. It's got to be something that's really, really important, hence being amended only 27 times. Article 5 talks about the process of amending the Constitution. All right, here we are, Article 5. The Congress whenever 2/3 of both chambers shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the individual states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the individual states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress. So, what is the process by which the Constitution can be amended? Well, there are several ways. The Congress can amend the Constitution, and the people themselves can amend the Constitution. But let's talk about the Congress amending the Constitution is far and away the most common method. So let's talk about that first. What does it take for Congress to create an amendment to the Constitution? Well, it requires a 2/3 approval vote in both chambers of the Congress. 2/3 in the House of Representatives and 2/3 in the U.S. Senate. That's the way that works. Now, once that 2/3 number is reached in both chambers, then that proposed, it's not an amendment yet. It's a proposed amendment. It doesn't become an amendment to the Constitution until something else happens. All right. Both chambers have approved the proposed amendment. They send it out to the individual states for approval. Fancy word, ratification. What does it take for a proposed amendment to become an amendment and become an active part of the Constitution? It takes a 3/4 majority. Now, folks, I joke with you and I tell you that I couldn't get 3/4 of you to agree on what your favorite ice cream is, much less something important like ratifying an amendment to the Constitution. And this was done on purpose. This was not an accident. This was to avoid frivolous amendments. 3/4, right? 75% is what it takes at the state level to ratify a proposed amendment. Now, there is another method of creating an amendment. Congress can do it, but the individual states can do this as well. All right, let me give you an example that is so ridiculous, but let's do this so I can make the point. What would happen if most of the states wanted to create an amendment to the Constitution that made cannibalism mandatory, right? Well, you can imagine probably Congress would want nothing to do with that. They don't want to put their name on something so bizarre. But what happens if the states really wanted that amendment? Just because Congress doesn't want to do it, does the proposed amendment die? No. The individual states can call conventions, and at those conventions they would vote on whether or not to create an amendment that made cannibalism constitutional, mandatory. If 2/3 of the states agree on this proposed amendment, then all of the states will vote on it. And once again, what does it take to make the cannibalism amendment real? It takes the approval, the ratification by 3/4 of the states. So it doesn't matter which method is used, whether the amendment comes out of the Congress itself or whether it comes out of these state conventions. If it is ratified by 3/4 of all the states, 3/4 of 50, you got to round up to the nearest whole number, 38, right? 37. then that amendment becomes real, and it doesn't matter which method is used. Article 5 continues by saying that provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. All right. There are several things that are contained here in this portion of Article 5. First of all, we know that written into the original Constitution was the ban on the Atlantic slave trade. Now, it did not go into effect immediately. As a matter of fact, it's odd. The rest of the Constitution went into effect the moment that it was ratified by the 9th state, and we know that that was New Hampshire. But this part of the Constitution did not go into effect for 20 years, the ban on the Atlantic slave trade. Now, historians have argued and debated for a couple of hundred years about why this was so. Why was this? Why didn't this go into effect immediately? And as a historian of the South, I say it was racism. Remember that slavery existed in all 13 states at this time, but most of the slaves lived in the South. I say that the delegates to the Constitutional Convention wanted to make sure that there were enough slaves living in the United States first, before they banned the Atlantic slave trade. In other words, before they banned introducing new slaves into the United States. Whatever the reason, the ban on the Atlantic slave trade did not go into effect until 1808. And Article 5 says that no amendment is going to change that. That is going to happen no matter what. There are several, so we refer to the ban on the Atlantic slave trade as an unamendable part of the Constitution. True or false, folks? Are there certain parts of the Constitution that cannot be amended? And the answer is true. Yes, that's true. One of them, you can't do away with the ban on the Atlantic slave trade. In 1808, it is going to happen, and by the way, it did. It talks about the first and fourth clauses in the 9th section of Article 1. Basically, fundamentally, that's taxes. Remember, in the original Constitution, there was no personal income tax. There was a sort of a flat tax that all Americans paid the same amount. Now, Article 5 says that you can't change that. But we have, haven't we? Haven't we? Yes, we have. And that is why some Americans say that the personal income tax that we have today is unconstitutional. However, I suggest that you not try to test that idea, because if you don't pay your taxes based on your opposition, right? There's going to be some bad things happen to you. You're going to have to pay fines, or you're going to wind up in jail. So you can complain about taxes, you can complain about the constitutionality or the unconstitutionality of a personal income tax, but it is here to stay. Also, it says one of the other unamendable parts of the Constitution is equal suffrage in the Senate. Remember the Great Compromise that was negotiated by Roger Sherman of Connecticut. Sherman and the delegates agreed that representation in the House of Representatives would be based on a state's population, but upon what would a state's delegation in the U.S. Senate be based? And the answer, of course, is equality. Every state gets the same number of U.S. senators, no matter if they're a small population or large population states. And you can't change that. That's unamendable. Every state forevermore will have the same number of senators in the U.S. Senate. That was rather short. That was Article 5. We finished that. Article 6. Article 6. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. An honest man pays his debts. All right, that's fundamental. That's basic. You don't make a debt and then run away from the debt and leave it unpaid. That is true for individuals, and that is true for nations. Now, Article 6 wanted to make it very clear in case there were any questions. Remember that the United States, operating under the Articles of Confederation, had made all kinds of debts, borrowed money from foreign countries and banks and all kinds of individuals. And then we adopt a new founding document. We swap. We abandon the Articles of Confederation and we adopt the Constitution. Now, does that give us the right then to abandon the debts that were made under the Articles of Confederation? And the easy answer is no. All debts, not some, not most, all debts contracted and engagements entered into, treaties, engagements, treaties, right? Entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. Honorable people and honorable nations pay their debts. Article 6, paragraph 2 says this Constitution and the laws of the United States, which shall be made in pursuance thereof, laws of the United States which shall be made under the Constitution, and all treaties made or which shall be made, past, present, future, under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the constitution of laws of any state to the contrary notwithstanding. It's rather confusing language, but it's really not. We refer to the Constitution as the law of the land, the supreme law of the land. Whenever there is a conflict between what the Constitution says is the law and what, for example, states say is the law, whenever there's a conflict, who always wins that argument? It's the national government. Now, it might take a while for the national government to finally win that argument. Let's acknowledge that. For example, the Civil Rights era. In 1954, Brown versus Board of Education of Topeka, Kansas said that segregation in public schools is unconstitutional. Now, it is true that some states immediately desegregated their schools because it was not only was the right thing to do, but it was the constitutional thing to do. Other states dragged their feet and had to be forced to segregate their schools. As a matter of fact, some schools, especially in certain southern school districts, did not actually completely comply with Brown versus Board until the early 1970s. Now, you do the math. That's a little less than 20 years. But what eventually happened, folks? What eventually happened is that the national law won the argument. Why? Well, because the Constitution is the supreme law of the land. Now, it goes further. Article 6, paragraph 2 goes further and says that the judges in every state shall be bound thereby. Anything in the constitution of laws of any state to the contrary notwithstanding. The judges of every state, their guiding principle is not state constitutions. It is the national constitution, the federal constitution, the U.S. Constitution. Remember, it's the judges who interpret the law. And this does not give much wiggle room to a state judge, does it? We've already established earlier here in paragraph 2 that the Constitution is the supreme law of the land. And then it says, fundamentally, judges are bound by the content of the Constitution. They don't have any wiggle room. They don't have any leeway. They must interpret the Constitution in a way that is faithful to the Constitution. And it doesn't matter what state constitutions say. You may or may not be aware that during the Civil Rights era, there was so much opposition to the desegregation or the integration, whichever term you prefer. There was so much opposition to that in the southern states that southern states wrote into their state constitutions that the segregation, the separation of races was good. It was constitutional. What does the sixth article say? No, it says no, that's not true. The U.S. Constitution is the supreme law of the land, and states cannot do that just because they disagree with something. In this case, the desegregation of public schools. Now, Article 6, remember what we've said umpteen times. That's a technical term, by the way. What we have said is that whenever the Constitution wants to make the point that something is really important, it repeats itself. And here we go. Article 6, paragraph 3. Fundamentally, using different words, but it fundamentally repeats what was in paragraph 2. Okay, so here we are, paragraph 3. The senators and representatives before mentioned, and the members of the individual state legislatures, and all executive, governor, right, and judicial officers, both of the United States and of the individual states, shall be bound by oath or affirmation to support this Constitution. Okay, let's stop right there. Just in case there was any doubt, it says, it goes into more detail, doesn't it? It says that every level of politician has to swear allegiance to the United States Constitution. That way, in the future, they will not be able to say, oh, I didn't know that that was in the, right? I didn't know that that was unconstitutional. I didn't know that I shouldn't do that. Senators and representatives, I mean, here's the list. Senators, representatives, members of the state legislatures, all governors, all judges, both at the federal level and at the state level, shall be bound by oath or affirmation to support this Constitution. So, ignorance is no plea, right? And then there's a semicolon, and something is thrown in here. I don't know. Honestly, I don't know why it's here. Probably because there was no other place to put it, so they just sort of attached it here. But it's important. No matter where it is, it's important. No religious test shall ever be required as a qualification to any office or public trust under the United States. Now, this has not always been the case in our country. There was a time, especially back in the colonial period and in the early days of our country, that in order to be elected to office, you had to be the member of the right church. Um, in New England, you had to be a Puritan, right? In Virginia, you had to be an Anglican. But by the time that 1787 rolls around, democracy is widening in the United States, and the religious test, the religious qualification, has been done away with in many of the 13 states. And here in Article 6, paragraph 3, it does away with it in the remainder of the states. No, that's pretty firm, right? No religious test shall ever, not then, not today, not in the future, shall ever be required as a qualification to any office or public trust under the United States. Article 7. The ratification of the conventions of 9 states shall be sufficient for the establishment of this convention between the states so ratifying the same. How many states had to ratify the Constitution before it became official, before it was actually put into place? And the answer is 9. There were 13 states, 9 of them had to approve it. Now, if you recall, there were all kinds of problems in ratifying the Articles of Confederation because in order for the Articles of Confederation to go into effect required unanimity. In other words, all 13 states had to approve. And we know that that caused all kinds of problems. As a matter of fact, it would take another few years for the articles to be ratified because the states were squabbling with each other. They were so jealous of each other. Well, many of the men who were at the Constitutional Convention had also served in the Articles Congress, and they knew the problems that had been caused by this unanimity issue. And so they wanted to make it easier to ratify the Constitution. Now, please be very careful. I didn't say that they wanted to make it easy. No, they wanted to make it easier. It was still hard, but it was easier. So 9 out of the 13 states had to ratify. That's roughly 3/4. You do the math. It's roughly 3/4 of the states had to ratify before it goes into effect. We also know, don't we, that eventually all 13 of the states did in fact ratify. But only 9 officially, constitutionally, were required before it went into effect. And we know that New Hampshire was in fact the 9th state. And then the Constitution as written in 1787 ends by saying, done in convention by the unanimous consent of the states present the 17th day of September in the year of our Lord 1787, and the independence of the United States of America the 12th, in witness whereof we have hereunto subscribed our names. Now, we've got to look at this sentence very carefully. It doesn't say, does it, that there was unanimous agreement among the 13 states to ratify. No. What it said was that there was unanimous consent among the states that were present. Now think back to some of the really early lectures that I gave you, sort of giving the run-up to the creation of the Constitutional Convention. What we said that only 12 states participated. Rhode Island never, not one day, not one moment participated. But the nation was composed of 13 states. Rhode Island was one of them. So it would have been incorrect, wouldn't it have been, if the Constitution had said, done in convention by the unanimous consent of all the states? Because Rhode Island wasn't there. So what they did, they sort of manipulated the wording. It's an accurate sentence, but if you don't know the history, you'll say, well, what the heck is going on? What it says is done in convention by the unanimous consent of the states present, right? And what that means is the 12 of them that are here. And of those 12, they all agreed that this Constitution should be sent out to the states for ratification. Okay, folks, we've completed the Constitution as written in 1787. Now, what we are going to do, of course, is we are going to continue our study of the Constitution, because we know that what is left is 27 amendments. And those 27 amendments are just about as long as the length of the original Constitution of 1787. So we're about half done, and that works out pretty well because we just finished taking the midterm, so we're positioned well here. Now, listen carefully. I know that one thing that I'm unable to do as I create these video lectures, I am unable to take your questions in real time. And that's one of the things that I enjoy the most is your questions. And I think that that's a real learning tool for you as well. So please remember that even though you can't question me on video, I'm just a talking head. You can give me a call if you have questions. You can email me if you have questions. You can text me. You have my telephone number. You have my iPhone number. You can text me. Please don't hesitate. I don't want you doing poorly because you hesitated to contact me. Now, please don't do this frivolously. If you have a real concern, a legitimate question, call me. If you just want to shoot the bull, leave me alone, because I've got a lot of students that I'm having to deal with. And as you can tell, my hair is turning white. All right. I'll see you soon for lecture number 2. This is the end of lecture number 1.